34, we're talking about mortgages, deeds of trust, and foreclosures. So the three voluntary liens are mortgages, deeds of trust, and land contracts. So we talk about voluntary liens because you volunteer for a mortgage, you volunteer for a deed of trust, and you volunteer for a land contract. All allow judicial foreclosures, but deeds of trust, which secure almost all loans in Arizona, are usually foreclosed through a trustee's non-judicial for procedure. Land contracts allow a seller to reacquire the property through a forfeiture process, which we'll discuss in the next unit. So this unit covers the following topics: notes and mortgages, mortgage parties, mortgage payoff procedures, mortgage foreclosure procedures, foreclosure bidding, notes and deeds of trust, deed of trust parties, deed of trust payoff procedures, deed of trust foreclosure procedures. So after completing this unit, you're going to be able to define hypothecation, state the purpose of a note and a mortgage, list the parties to a mortgage, discuss lender requirements when a mortgage is paid off, list and discuss the steps in a judicial foreclosure, explain the bidding procedure at a foreclosure auction, state the purpose of a deed of trust, list and define the parties to a deed of trust, discuss lender requirements when a deed of trust is paid off, and list the steps in a non-judicial foreclosure of a deed of trust. Okay, so you're going to need to do some independent study. I'll go over the unit summary and the unit quiz. All right, so for the unit summary, you need to review these key terms or these key points. Hypothecation is a pledge of property as security in which the borrower retains possession of the collateral. So again, hypothecation, when you hypothecate, that's a pledge of property as security. The parties to a mortgage are the mortgagor, the borrower, and the mortgagee, the lender. Right? What's the part? So if you get asked, what is the parties to a mortgage? Right? So it's the mortgagor. The mortgagor is the borrower, person buying the house. They're borrowing, the mortgagor, and the mortgagee. So think about it like, whenever you deal with the mortgage, the mortgagor, they're the borrower, and the mortgagee is the lender, right? Mortgagee is the person giving the loan, that's the lender, and a mortgage. So mortgages, they're talking about loans. You got mortgagee, lendee, right? If you think about it like that, that's the lendee, the lender, mortgagee, lendee, lender, mortgagor, borrower. Think about those two things: mortgagor, borrower, mortgagee, lendee. So the mortgagee is the lender. The promissory note is the evidence of the debt, while the mortgage secures the debt with the property. When the note is paid off, defeasance occurs, and the lender must deliver a satisfaction of mortgage to the borrower, or the borrower, mortgagor, within 30 days. When a mortgage is in default, the lender's only foreclosure option is a judicial foreclosure. A judicial foreclosure proceeds as follows. A lawsuit is filed in court and a lis pendens is recorded. The debt is fully accelerated. The court renders a decision. If the court's judgment is against the borrower, the mortgagor, the sheriff is ordered to sell the property at public auction. Right? So who's selling the property? The auction on behalf of the bank. Right? At a public auction, a sheriff sale is held on the courthouse steps, and sold to the highest bidder. So if you want to know where to go buy, houses that are foreclosed, go to the courthouse. Right. The high bidder receives a sheriff's certificate of sale. The borrower has a 6-month statutory redemption after the sheriff sale. Again, the borrower has a 6-month statutory redemption, right? So they can potentially get it back in 6 months. If the borrower does not redeem the property, the sheriff delivers a sheriff's deed conveying ownership. So that's after the 6 months to the bidder certificate holder. Prior to the sheriff's sale, the borrower has equity of redemption. After the sheriff's sale, the borrower has a 6-month statutory right of redemption. Money bid in excess of the amount owed belongs to the borrower. If there is an insufficient amount bid, a deficient judgment is possible against the borrower. The parties to a deed of trust are the trustor, the borrower, the beneficiary lender, and the trustee. When a deed of trust is signed, the trustor conveys the legal title to the trustee. The trustee may only act under instructions from the beneficiary and in two circumstances: upon payoff and upon default. Upon payoff and upon default. Upon defeasance, the trustee must convey the legal title back to the trustor through a deed of reconveyance within 30 days of payoff. So again, upon defeasance, the trustee must convey the legal title back to the trustor through a deed of reconveyance within 30 days of payoff. Upon default, the beneficiary may choose to foreclose through a judicial foreclosure or through a non-judicial trustee's foreclosure. The non-judicial trustee's foreclosure proceeds as follows. So you have a judicial foreclosure, and that has steps. And then there's a non-judicial trustee's foreclosure, and that has these steps. So trustee records a notice of default and trustee sale. This notice must be sent by certified mail to the trustor within 5 days of being recorded. The notice must also be sent to all subordinate lien holders. The trustor has a minimum of 90 days from the notice to reinstate the loan by bringing all payments to current, plus any trustee's fees and foreclosure costs. If the trustor does not reinstate the loan, the trustee may sell the property at public auction to the highest bidder. The high bidder receives a trustee's deed upon sale from the trustee. There is no redemption right for the trustor after the trustee's sale. Arizona law prohibits a deficiency judgment after a trustee's sale if the property is 2.5 acres in size and used as a single one-family or single two-family dwelling. So again, Arizona law prohibits a deficiency judgment after a trustee sale if the property is 2.5 acres in size and used as a single, if the property is 2.5 acres in size and used as a single one-family or single two-family dwelling. Number one, the mortgage foreclosure sale did not produce enough to satisfy the debt. What could the mortgagee, right, the lender, what could the mortgagor do? Right, we'll talk about the bank. Mortgagee, lendee is the lender. What could the mortgagee, the lender, do? Alpha, it could file for a deficiency judgment against the borrower. So when we say file for a deficiency judgment, against the borrower, right? The borrower is the mortgagor, mortgagor. So they're filing deficiency judgment because they were late 3 months in a row and they're going to foreclosure. So now they got to file a deficiency judgment and take them to court. So file for a deficiency judgment against the borrower. So the mortgage foreclosure sale did not produce enough. The mortgage foreclosure sale did not produce enough to satisfy the debt. What could the mortgagee do? They could file for a deficiency judgment against the borrower. So, what happens is like you do a short sale, right? You owe $200,000. It's only worth $100,000. So, and you say you owe $200,000, right? And they sold it for $100,000, so they only got $100,000. They need another $100,000, and they can't get it from the sale of the house, so they're gonna have to sue you, sue the borrower. The purpose of collateralizing a note. Purpose of collateralizing a note with a deed of trust is to what? Is to protect the lender. Protect the lender. So when you collateralize a note with the deed of trust, what does it do? It protects the lender. The lender, the mortgagee, right? Mortgagee, lendee, mortgagor, the lender. Does it protect the borrower? No. Protect the trustee? No. Protect the mortgagee? So mortgagee, there's the lender. Defeasance clause in a deed of trust allows for what? Allows for cancellation of the lender's claims upon full note payment. Cancellation of the lender claims upon full note payment. So a defeasance clause in a deed of trust allows for cancellation of the lender's claim upon full note payment. So say you pay off your house, right? Then you get a defeasance clause. The defeasance clause says it cancels the lender's claim upon full note payment. So you pay the note in full, you own the house, it's no longer the lender's, it's yours. You own it. You're the borrower no longer is the owner. The borrower is the owner now. So a defeasance clause kicks in that says, lender doesn't have any claim to it. So that's a defeated, right? Defeasance clause, defeated. You defeated the lender finally. That's a good way to remember. Defeasance, you defeated the lender, so they have no claim upon that full note. The trustee to foreclosure, no. The lender's protection against forgery, no. Non-assumability of a loan, no. After a share of sale, a trustor has a statutory right of redemption of alpha 6 months. 6 months. So after a share of sale, a trustor has a statutory right of redemption of 6 months. 9 months, no. 1 year, 3 years, no. All the following elements are part of the trustee's non-judicial foreclosure process except what? Delta, except acceleration. That is not part of the non-judicial foreclosure process. Reinstatement, yes. Recorded notice, yeah. Public auction, yeah. In a non-judicial foreclosure of a deed of trust, notice is given in which order? Bravo. Constructive, then actual. Constructive, then actual. So in a non-judicial foreclosure of a deed of trust, notice is given in which order? Constructive, then actual. Service of process, then actual, then constructive, no. Actual, then constructive, no. Legal, then actual, then constructive, no. A monthly payment is due on January 1st and has not been received by January 7th. In order to begin a foreclosure, the beneficiary must what? Delta instruct the trustee to take action. Instruct the trustee to take action. So a monthly payment is due on January 1st and has not been received by January 7th. In order to begin a foreclosure, the beneficiary must instruct the trustee to take action. Wait 30 days? No. Wait 60 days? No. File a notice of foreclosure to the newspaper? No. A buyer obtains a loan on a parcel of land and secured by a deed of trust. Later, the buyer moves a mobile home onto the lot and defaults on the deed of trust. Which of the following is true? C. The lender may foreclose on the land only. The lender may foreclose on the land only. So a buyer obtains a loan on a parcel of land and secured by a deed of trust. Later, the buyer moves a mobile home onto the lot and defaults on the deed of trust. Which of the following is true? The lender may foreclose on the land only. The lender may foreclose on the land and mobile home? No. Lender may foreclose under the Homestead Act? No. Lender may foreclose on the mobile home only? No. On the land only. In a judicial foreclosure of a voluntary lien, at what point does the property owner lose the ability to sell the property? Bravo. After the statutory right of redemption expires. After the statutory right of redemption expires. So in a judicial foreclosure of a voluntary lien, at what point does a property owner lose the ability to sell the property? So it's after the statutory right of redemption expires. When the sheriff hammers down the sale at the auction? No. After the equity of redemption expires? No. At the time the lis pendens is recorded? No. Naked legal title best describes the interest of a alpha trustee under a trust deed. Naked legal title best describes the interest of a trustee under a trust deed. Trustee under a trust deed. It's naked legal title. Is it trustee in an agreement for sale? No. Trustee in a mortgage? No. Beneficiary to owner? No. Regarding a trust deed foreclosure, which of the following is true? Alpha, the debtor receives a notice of sale. The debtor receives a notice of sale. So regarding a trust deed foreclosure, which of the following is true? The debtor receives a notice of sale. Debtor receives a notice of sale. Does the debtor notify the trustee of its default? No. Does the trustee notify the beneficiary of default? No. The mortgagor, right, that's the buyer. The buyer would notify the trustee? No. The debtor receives a notice of sale. Once a deed of trust is originated, who owns the property? So alpha, the trustor. Once a deed of trust is originated, who owns the property? The trustor. Trustor owns the property once a deed of trust is originated. Is it the trustee? No. Assignee? No. Beneficiary? No. If a borrower in a judicial foreclosure abandons the property, the statutory redemption period could be reduced to alpha 30 days. 30 days. So if a borrower in a judicial foreclosure abandons the property, so that borrower just abandons the property, the statutory redemption period could be reduced to 30 days. So if you abandon your property, The statutory redemption period could be 30 days. 60, 90, 6 months? No. When a loan is secured by a deed of trust, who holds the deed of trust documents? So this is Delta, the beneficiary. When a loan is secured by a deed of trust, who holds the deed of trust documents? The beneficiary. The beneficiary holds the deed of trust documents. Beneficiary is going to hold those deed of trust documents. Mortgagee? No. Trustee? No. Trustor? No. After a notice of default and trustee's sale has been recorded, the trustor has a certain amount of time during which the loan can be reinstated by paying delinquent payments. This right is known as the right of reinstatement. So after a notice of default and trustee's sale has been recorded, the trustor has a certain amount of time during which the loan can be reinstated by paying delinquent payments. This right is known as the right of reinstatement. Right of redemption? No. Rescission? No. First refusal? No. So this right is known as the right of reinstatement. What is the redemption period after a non-judicial foreclosure of a trust deed? So there is no redemption. There is no redemption period. So what's the redemption period after a non-judicial foreclosure of a trust deed? Right, so keep in mind the key word here is non-judicial. Non-judicial, there's no redemption period. So what's redemption period after a non-judicial foreclosure of a trust deed? When can they recover their property? There's no redemption period. They can't get back their house once they lost it. So 9 days, 6 months, 3 years, no. Which party or parties must sign the trust deed? So it is the trustor, right? Which party or parties must sign the trust deed? Trustor. Trustor must sign the trust deed. So again, trustor needs to sign the trust deed. Trustor signs the trust deed. After a deed of trust, so is the trustee? No. Trustor and beneficiary? No. Trustor? Yes. Is it the trustor and trustee? No. After a deed of trust, foreclosure, sale, which of the following is true? C. A trustee's deed is given to the new owner. A trustee's deed is given to the new owner. So after a deed of trust, foreclosure, sale, which of the following is true? After a deed of trust, foreclosure, sale, which of the following is true? A trustee's deed is given to the new owner. So a deed of reconveyance is given to the trustor? No. A note is marked paid and returned to the trustor? No. The trust deed is returned to the trustor? No. A trustee's deed is given to the new owner. A deed of trust is paid off to the beneficiary. So the beneficiary. So a deed of trust is paid off to the beneficiary. So who's it paid off to? To the beneficiary. Beneficiary is the person that the deed of trust is paid off to. Is it paid off to the trustor? No. Trustee? No. Escrow company? No. A deed of trust is paid off to the beneficiary. To pledge real property as collateral is called what? Hypothecate. So when you're hypothecate is to pledge real property. Hypothecate. So when you hypothecate something, you're pledging real property as collateral. Hypothecate collateralizes real property. You're pledging real property as collateral, and that's called hypothecation. Is it devise? No. Demise, descent? No. Which of the following persons is not a party to a trust agreement? It's a mortgagor, right? That's the borrower, right? Which of the following so the borrower is not a party to a trust agreement. Mortgagor. Mortgagor is not a party to a trust agreement. Is it the trustor? No. Trustee? No. Beneficiary? I'm sorry. Trustor? Yes. Trustee? Yes. Beneficiary? Yes. The mortgagor is not a party to a trust agreement. After the mortgage and all debts are paid in a foreclosure sale, any excess funds would go to the Delta foreclosed owner. Foreclosed owner. So, after the mortgage and all other debts are paid in a foreclosure sale, any excess funds would go to the foreclosed owner. Foreclosed owner. Would it go to the lender? No. Creditor? No. Buyer at the sale? No. What does the high bidder receive at a judicial foreclosure sale? Answer is Delta certificate of sale. Certificate of sale. So what does the high bidder receive at a judicial foreclosure sale? A certificate of sale. What does the high bidder receive at a judicial foreclosure sale? They get the high bidder at a judicial foreclosure sale gets the certificate of sale. Do they get the sheriff's deed? No. Treasurer's deed? No. Trustee's deed? No. If it's a high bidder, think of it as you get a certificate of sale. The borrower using a trust deed is called the trustor. The borrower using a trust deed is called the trustor. The borrower using a trust deed is called the trustor. Trustor is where the borrower uses a trust deed. So trustor, borrower, same thing. Borrower using a trust deed is called the trustor. Are they the mortgagor? No. Beneficiary? No. Trustee? No. What is the first step taken after the notice of default and trustee sale is recorded in a non-judicial trust deed foreclosure? This is alpha. The notice is sent to the debtor. Notice is sent to the debtor. So what's the first step taken after the notice of default and trustee sale is recorded in a non-judicial trust deed foreclosure? The notice is sent to the debtor. Alpha. Is it the debtor has 60 days to redeem? No. Trustor will file lis pendes? No. Trustee will order the beneficiary to proceed with the foreclosure? No. 26. After notice of default and trustee sale has been recorded, how long does the trustor have to reinstate himself in the property? Alpha. 90 days. 90 days. So after a notice of default and the trustee's sale has been recorded, how long does the trustor have to reinstate himself in the property? It's 90 days. So 120, no. 6 months, no. 3 years, no. All right, next up is going to be Unit 35. We're talking about land contracts, distressed transactions, and fix and flips.